Revata madam, please start.
Yes, ma'am. सर्वांना माझा सादर नमस्कार. मी डॉक्टर यमुना रेवतकर, सहाय्यक प्राध्यापक इतिहास विभाग, महात्मा बोधिशीय शिक्षण संस्था संचालित मनोहरराव कांबडी महाविद्यालय नागपूर, रवींद्रनाथ टागोर कॉलेज डोंगरगाव नागपूर आणि मातृसेवा संघ इन्स्टिट्यूट ऑफ सोशल वर्क नागपूर यांच्या संयुक्त विद्यमानं कार्यक्रमाला उपस्थित असलेल्या समस्त मान्यवरांचे, प्राध्यापकांचे आणि विद्यार्थ्यांचे शब्दसुमनांनी हार्दिक हार्दिक स्वागत करते. आज शनिवार दिनांक 26 ऑक्टोबर 2024 रोजी इंट्रोडक्शन टू इंटेलेक्च्युअल प्रॉपर्टी राईट्स या विषयावर रिसर्च अँड कन्सल्टन्सी सेल ऑफ आयक्यूसी या कार्यक्रमाअंतर्गत आभासी व्याख्यान पद्धतीने एक दिवसीय वेबिनारचे आयोजन करण्यात आले आहे. आजच्या कार्यक्रमाला प्रमुख वक्ता म्हणून आपल्याला लाभलेले डॉक्टर विजयकुमार एन मुलमाणी सर, डिपार्टमेंट ऑफ लायब्ररी अँड इन्फॉर्मेशन सायन्स, संगमेश्वर कॉलेज सोलापूर यांचे मी महाविद्यालयाच्या वतीने शब्दसुमनांनी हार्दिक हार्दिक स्वागत करते. वेलकम सर. कार्यक्रमाचे आयोजक मनोहरराव कांबडी महाविद्यालयाच्या प्राचार्य आदरणीय डॉक्टर उषा साकोरे मॅडम, रवींद्रनाथ टागोर कॉलेजचे डायरेक्टर आदरणीय डॉक्टर जयंत गांगरेड्डीवार सर, मातृसेवा संघ इन्स्टिट्यूट ऑफ सोशल वर्क कॉलेजचे प्राचार्य आदरणीय डॉक्टर पुरुषोत्तम बोरकर सर यांचेही मी मनपूर्वक हार्दिक हार्दिक स्वागत करते. महाविद्यालयाच्या आयक्यूसी नॅक कोऑर्डिनेटर डॉक्टर मीनाक्षी वासनिक मॅडम, प्रोफेसर नासिर पठाण सर, डॉक्टर प्रिन्स आगाशे सर यांचेही मी शब्दसुमनांनी हार्दिक हार्दिक स्वागत करते. IPR म्हणजे बौद्धिक संपदा अधिकार. बौद्धिक संपदा मनाच्या निर्मितीचा संदर्भ देते, जसे की आविष्कार, साहित्यिक आणि कलात्मक कामे, रचना आणि वाणिज्यामध्ये वापरलेली चिन्हे, नावे आणि प्रतिमा. IP ला कायद्याने संरक्षित केले आहे. उदाहरणार्थ पेटंट, कॉपीराईट आणि ट्रेडमार्क. ज्यांनी जे काही शोध लावले किंवा तयार केले त्यापासून मान्यता किंवा आर्थिक लाभ मिळण्यास सक्षम करते. नवीन संशोधकांचे हित आणि व्यापक सार्वजनिक हित यांच्यात योग्य संतुलन राखून सृजनशीलता आणि नाविन्यपूर्ण वाढू शकेल अशा वातावरणाला प्रोत्साहन देण्याचे IP प्रणालीचे उद्दिष्ट आहे. हे या वेबिनारच्या माध्यमातून आपण डॉक्टर विजयकुमार मुलमाणी सर यांच्याकडून जाणून घेणार आहोत. मनोहरराव कांबडी महाविद्यालयाच्या प्राचार्य डॉक्टर उषा साकोरे मॅडम कार्यक्रमाचे प्रास्तावित करतील अशी मी मॅडमला नम्र विनंती करते. डॉक्टर उषा साकोरे मॅडम.
Thank you, Yamuna madam, and good morning, everyone. And of course, it is an honor to have with us today Dr. Vijay Mulmani from Sholapur University, an expert in the field of intellectual property rights. Students, in a world driven by creativity, innovation, and knowledge, understanding the concept of IPR has become vital for young minds like you. Intellectual property rights refer to the legal protections granted to creators for the unique ideas, inventions, literary and artistic works, designs, and symbols. These rights are not only safeguard the interests of the creators, but also encourage innovation and creativity by providing them with recognition and rewards. Friends, for undergraduate students, awareness about IPR is particularly significant as you are the threshold of exploring new fields, acquiring skills, and possibly creating original works. Whether it be technological innovations, artistic creations, or literary compositions, your contributions are valuable and need to be protected. Today, Mr. Malmani will help us understand how intellectual property rights impact the current economic and social landscape. He will shed light on various types of IPR, including copyrights, trademarks, patents, industrial designs and explain why it is crucial to recognize and respect others' intellectual property rights while safeguarding your own. Let us all be attentive and inquisitive to grasp this critical knowledge and make the most of the opportunity to learn from our resource person today. Thank you.
थँक्यू सो मच मॅम. आजच्या या कार्यक्रमाचे उद्घाटन येथे संपन्न झाले आहे. आजच्या या कार्यक्रमाला प्रमुख वक्ता म्हणून आपल्याला लाभलेले डॉक्टर विजयकुमार मुलमाणी सर यांचा मी थोडक्यात परिचय करून देऊ इच्छिते. डॉक्टर विजयकुमार मुलमाणी सर पुण्यश्लोक अहिल्यादेवी होळकर सोलापूर विद्यापीठ सोलापूर संलग्नित संगमेश्वर महाविद्यालय सोलापूर येथे ग्रंथपाल, ग्रंथालय आणि माहितीशास्त्र विभागाचे सहसमन्वयक आणि विभाग प्रमुख म्हणून गेल्या 20 वर्षापासून कार्यरत आहे. सर सोलापूर विद्यापीठ येथील ग्रंथालय आणि माहितीशास्त्र विषयातील पीएचडीचे मार्गदर्शक असून त्यांच्या मार्गदर्शनाखाली 3 विद्यार्थी पीएचडीचे संशोधन कार्य करीत आहेत. सरांचे ग्रंथालय व माहितीशास्त्र विषयातील संदर्भ ग्रंथांचे 9 पुस्तके देखील प्रकाशित झाली आहेत. सर विविध समित्यांवर कार्यरत आहे. त्यामध्ये BOS, IQAC, API मेकिंग, परीक्षा, प्रवेश, प्लेसमेंट इत्यादी. सरांनी UGCचा लघुशोध प्रकल्प पूर्ण देखील केलेला आहे. सर 2018 ते 20 या कार्यकाळात सोलापूर विद्यापीठात ग्रंथालय आणि माहितीशास्त्र विषयातील अभ्यास मंडळाचे अध्यक्ष होते. सोलापूर विद्यापीठात ग्रंथालय व माहितीशास्त्र विषयाच्या अभ्यासक्रम निर्मिती समितीचे सदस्य देखील आहेत. सरांनी आंतरराष्ट्रीय आंतरविद्याशाखीय परिषद, राष्ट्रीय कार्यशाळेचे आयोजन देखील केलेले आहे. त्यांनी अनेक सेमिनार, परिषद कार्यशाळेत संसाधन व्यक्ती, रिसोर्स पर्सन म्हणून व्याख्यान देखील दिलेले आहे. मुलमाणी सरांचे विविध जर्नल्स, सेमिनार, परिषदा, कार्यशाळांमध्ये 50 पेक्षा जास्त शोध निबंध प्रकाशित केलेले आहे. अशा उच्च विद्या विभूषित सरांचा परिचय बराच मोठा आहे. त्यामुळे मी सरांचा जास्त वेळ न घेता सरांना विचार मंचावर सादर आमंत्रित करते. डॉक्टर विजयकुमार एन मुलमाणी सर.
Thank you, madam. So, good morning to all of you. So, Dr. Usha Sakure, Principal, Madam, MANOHARRAO, KAMDI, Mahavidyalaya, Nagpur. Honorable Dr. Purushottam Borkar, Sir, Principal, MATRU SEWA SANGH Institute of Social Work, Nagpur. Dr. Jayant Ganga Reddy, Sir, Principal, Ravindranatha Tagore College of Arts, Science and Commerce, Dongargaon. Respected coordinators, Dr. Yamuna Revatkar, Madam, and Dr. Prince Agashe, Sir, and Professor Nasir Patan, Sir. So it gives me an immense pleasure to talk a few words about the intellectual property rights. So, Madam, please share the PPT. Can you?
Yes, sir.
Please.
Sir, ready?
Yeah, definitely. Intellectual property rights. So next, we just go. In case you just allow me to use it, then I can.
Madam, the screen is ready. So if you want to change the slides, please suggest me, sir.
Yeah, next year.
If possible, please zoom it.
Yes.
So presentation of the topic is like this: Introduction to IPR, National IPR Policy, Objectives of IPR Policy, Historical Perspectives of IPR, Types of IPR, that is patent, copyrights, designs, trademarks, geographical indication, plant varieties, then data protection, and conclusion. Next. So here we can see that thinking mind, that is idea, that is creation. So how the thinking mind is there? Next. So what is intellectual property? That is there. So just next. So imagination is more important than knowledge. So we can see that imagination is more important than the knowledge, and the how the intellectual property goes on. Next. So property means things belonging to someone or possessions collectively. That is real land, like a personal car, jewelry, etc., precious belongings, and etc. Intellectual property is a creation of mind, inventions, and literary artistic work, that is symbol, names, images, that is used commercially. Next. So creations of human mind, that is knowledge assets created through manifestation of ideas, conferred on creations, especially on the basis of intangible knowledge assets and tradable commodities. Next. So IPR plays a very important role, that is assets for enterprise, tool for business competitiveness, IPR enforceable by law and new wealth of nations. Next. So it gives the inventor or creator an for exclusive right for a certain period of time for the use of its invention or creation. And it is human intelligence, just as artistic, literary, technical, and scientific constructions. IP plays a very important role in the modern economy. Next. The very existence of intellectually is in the cave paintings, especially earlier when we see it. Coins, artistic work, sculptures, and it was recognized in WIPO, that is World Intellectual Property Organization, which was established in 1967 and headquarters in Geneva, that is Switzerland. Next. Here, the need of IPR is it encourages innovation, economic growth, safeguards the rights of creators, ensures ease of doing business, and facilitates the transfer of technology. Next. So nature of intellectual property rights. So nature itself, it shows that so India is in the priority watch list of USA under special 301 system, and intellectually insists of some amount of novelty or originality to gain protection, and it is the duration is very much specific, and it does not provide any monopoly over the property, and it is protected with respect to intellectual property, that is the use or value of ideas or expressed ideas. Next. So importance of IPR. So importance, it is very important that it gives the inventor exclusive rights of dealing, permit avoid of competitors and increase entry barriers, and allows entry to technical market, and generate steady income by issuing license. Next. So in national IPR policies, that is Creative India and Innovative India, the vision statement itself is an India where creativity and innovation are stimulated by intellectual property rights for the benefit of all, and an India where intellectual property promotes advancement in science and technology, arts and culture, traditional knowledge, and biodiversity resources. So in the missions, next. In the mission statement, it is very much important that it is a dynamic, vibrant, and balanced intellectual property system, and it fosters the creativity and innovation, and focus on enhancing access to healthcare, food security, environmental protection, etc., etc., social, economic, and technological importance. Next. So 7 objectives of IPR policy it is there. So it is very important that the Ministry of the Department has given the 7 objectives, that is IPR awareness outreach promotion. It means to create a public awareness about the economic, social and cultural benefits of IPRs among the sections of the society, and generation of IPRs, that is to stimulate the generation of IPRs. Next, IPR legal and legislative framework, that is to have a strong and effective IPR laws which balance the interests of rights owners with a larger public interest. IPR administration and management, to modernize and strengthen service oriented IPR administration. Commercialization of IPR, that is get value for IPRs through commercialization. And next, enforcement and adjudication, that is to strengthen the enforcement and adjudicatory mechanism for combating IPR infringements. And human capital development, that is to strengthen and expand human resources and institutions and capabilities for teaching, training, research and skill building in IPRs. So national and international dimensions of IPR, that is it is governed by the national laws and rules of a given country, and it is an international convention ensures the minimum rights and provides certain measures for enforcement of rights by the contracting states. Next. So types of IPR here. So types of IPR when we see here, that is there are main here 4 types: trade secrets, trademarks, copyrights and patents. The others are included with the, that is designs, geographical indication, plant varieties and data protection. Next. So historical perspectives of IPR when we consider here, we can see that the Chinese pots were there. It was in 2700 BC. We can see it very clearly that it is the name of the emperor and the name of the maker was shown in the Chinese pots. Next. In the stamps on bricks by the Roman, we can see till today that on the bricks some initials were also used. That is, earlier stamps on bricks were there, and by brick maker for the purpose of identification, that was there, started in the 2nd century BC. Next. Potter's mark or Greek and Roman times. That is Potter's mark for Greek and Roman, that is appeared, and you can see that also here how the identification of the marker is there. Next. Barber's pole. Earlier the barber's pole was there, and it used to be the location of the business, and the business was to be considered as a most important aspect earlier. So next. So merchant's mark was there. So when you can see the merchant's mark, it was in the 10th century that was shown, and it was referred as a proprietary mark also. You can see that how the people have been gathered there to gathered for the purpose of business. Next. So it started in 1266 AD, that is the English Parliament enacted a law, and as early as in the 13th century also there. Next. The 14th and 15th centuries, then it went up to 16th century, and the British Trademark Act of 1875 that have provided the formal registration trademark, and thus registration was considered the prima facie. So next. So types of IPR, as I said you, that we can go one by one, that is patents are there, trademarks, then copyrights, designs, plant varieties, geographical indication. Next. So here you can see that the patents, how the ownership, exclusive rights, law, that is contract, application, property, plant granted and with a permission. So it is just a symbolic representation that how it patent should be done. Next. So patent. So when we see that patent, it is derived from the Latin word that is pater, means to lay open to public. So Merriam-Webster's dictionary defines it readily obvious or intelligible. And patent is a statutory right for the invention granted for minimum period of time to patentee by the government, and it provides new and useful ideas. An invention is defined with a new product or process. Next. So criteria for patentable invention. So when the criteria is there, so what are the patentable invention it includes? That is novelty, inventive step, capable of industrial application, unity of invention, patent nomenclature, and it is valid for 20 years. Next, patentability, that is patentable and non-patentable. Here we can see that in the patentable, novelty, practical use and utility should be there. Some new characteristics other than the existing knowledge should be there. Inventive step, which is non-obvious, invents any new and useful process, that is machine, manufacture or composition of matter or any new useful movement it should there. Even the non-patentable, when we divide it, so mere idea, it is not a non-patentable. Theory not possible to use commercially, and already known characteristics it cannot be done. Contrary to public order or morality, mere discovery of scientific principle, it is not there. Mere discovery of unknown substance, it is not at all included. Next. So when we see the evolution of IPR laws in India, that is 1856 to till 2002, it was there. So it has been started with the British in 1856. They have implemented the first patent statute in India. Later on, 1888, that is 1872 Act of for Design and 1883 Act of Patents, 1911, 1970, 1999 and 2002. Next. So these are the highlights we can see. Stages of filing to grant of patent. It is nothing but here the filing of application, that is provisional. It is in the flow chart. It is given very clearly that so publication or of application, that is there, and request for examination. Then it will go for the examination and issue for the further implementation and grant of patent. Then if it is not there, third party representation will be there. Then decision of the controller. Then it goes for the opposition, and next appeal and appellate the board or revocation. Next one. So here patent process is there. So like that, it is also here in the diagrammatic representation we have shown there how the patent process is to be done. Next. So filing of the patent application. So when you want to file the application, that is patent can be filed only on the payment of full fees, that is there first of all. Then fee is charged on the basis of number of pages and number of claims, and no extra fee is charged up to 30 pages and 10 claims. And power of attorney if applicable, and application, specification and other documents should be either in Hindi or English language. If application discloses sequence listing of nucleotides or amino acids, it should be filed in the electronic form. Next one. So documents required. What are the documents to be required actually here? So here the application form, proof of right to apply. So that is given according to the paragraph of 9 of 1, and provisional of or complete specification, statement of foreign filing, declaration as to inventorship, request for early publication, request for examination of application for patent, power of attorney if required, certified copy of convention, and then abstract of invention and drawings if any, and fees, that is in cash or check or other mode. Next. So patent registration process, that is how to the registration process will be there. So all documents and copies of the document should be sent to the patent office. So it should be the controller will be with written or type written, or it should be in English language if it is there. Then the size of the paper should be of A4 size with a margin of 4 centimeters. Next. So copyrights. So I will go for the copyright. When the copyright is there, so how the copyright, what are the copyrights, and how the intellectual property rights it is going to be used. So it protects the rights of the author, novel, films, computer programs, etc. And other organizations. So here the copyright, it is the right to make a copy and reproduce adaptations and translations with a meaning communication to the public. Next. So there should be the slight variations in the composition of the rights. That is governing law, India Copyright Act 1957. It is the main important thing. Royalties payable to the owner of the copyright, that is creator or the writer. Next. Copyright protection. So when the copyright protection is there, it is going to protect the expression. And copyright, it is safeguards the rights of the authors over the creations. Then protecting and rewarding creativity, motivate others to create. Then economic and social development of a society is depending on the creativity. Next. So that is exclusive right is given to the author of the original work, and types of original works that are protected under the copyright, that is literary work. In that one, dramatic works like scripts of films and dramas, musical works, that is for example melodies. Then artistic works, that is for example paintings, photographs, sound recording, cinematography films, and photography. Next. So bundle of rights, that is including right of reproduction, communication to the public, adaptation and translation of the work. So copyright does not ordinarily protect titles, names, short word combinations, slogans, short phrases, methods, plots, or factual. Next. Scope and duration, that is given here. So the scope and duration of the protected provided under the copyright law varies with the nature of the protected work, especially the original literary, dramatic, and musical, artistic. That is, duration is lifetime of the author, or 60 years of the counted from the author, year from the year of the death of the author. Cinematograph films, for sound recordings, photographs, posthumous publications, anonymous and pseudonymous publications, and works of government and works of international organs, that is 60 years, which is counted from the year following the date of publication. Next. So broadcast and reproduction right, that is a special right that is there. Broadcasting organization, which broadcast is for the 25 years and beginning of the calendar year, and the next, that is broadcast is made. And performance right is there, that is whichever the performation is there, performance, that is 50 years from the beginning of the calendar year. So that is in the year in which the performance is made. Next. So Copyright Act, that is early history. When we see here, it started with in the 1914, that is Indian Copyright Act, which was enacted the first time in 1914, primarily based on the UK Copyright Act 1911. In 1957, after independence, the Comprehensive Copyright Act was enacted. That is in the year 1957, to consolidate the laws right related to the copyrights in India. In 1994, definition of literary work, that is consistent with a definition of computers and computer programs, harmonizing with Rome Convention in 1961 by providing protection to the rights of the performers. The concept of registration of copyright societies for collective management of the rights is also there. Then next, in 2012, again the Copyright Amendment Act was there, and 2012 notified on 8/6/2012, and provisions in conformity with the WIPO Treaty and WIPO Performance Phonograms Treaty. The definition of copyright as exclusive right author of a work which is the owner of the copyright. Semiconductor integrated circuit design layout and 2000 semiconductor integrated circuits layout designs were also enacted at that time. So next, why should one get their works copyright? So there is a simple question that why the copyright should be there. So by registering your copyright work, so you create a public record of your work and concrete proof that you are the owner of the creative work. If someone copies your work, you can sue them for the copyright infringement. Copyright owners have the exclusive right to reproduce the work in any material form, to issue copies of the work to the public, to perform the work in public or make any translation or adaptation of the work, to sell or give an hire or offer for sale a copy of work. So next, what are the documents required? So documents required here: 2 copies of the work and DD or online payment, power of attorney if filed through attorney. If yours is an artistic work, then you would also require a search certificate from the trademark office, that is TM60. If yours is a computer software, then source code and object code of the work are also required for verification. NOC from legal heads if the author is deceased, and NOC from the publisher if the work is published and publisher is of different applicant. NOC from the author. So next, so process for registering copyright, that is obtaining copyright certificate, and it is classified into 3 stages, that is filing, examination and registration. So if any are removed to the satisfaction of the copyright registry. Please next. Next, how can the copyright be registered through legal rasta? So even you can go to the website www.legalrasta.com and you can register the copyright registration. So next, so legalrasta.com. So you can see here www.legalrasta.com is there, and here the legalrasta.com, it gives you the each and every stepwise how to register the copyright. With this one, you can apply the copyright act. Next, so we can see the designs here. So we are going for these designs. You can see the design here, how the designs are there. Next, so here also the designs, you can see that. Next, similar designs you can find it in the next also. Here the sari designs are there. Next, South Indian design, you can see that. So these are the designs are there. Next you can go. So the next IPR is of the designs. Here design means only the features of shape, configuration, pattern or ornament or composition of lines or color of combination. So thereof applied to then any article which is in the finished article appeal to and are judged solely by the eye. Design does not include any mode or principle or construction or anything. In 1957 Act, that is Copyright Act, it was there. And in 1958, that is Trade and Merchandise Marks Act, it was there. So it is valid for 10 years and extendable by 5 years more. So industrial design are of great commercial value. So it is having the shape of configuration of the article can often be a great selling point. So next. So when we go through the Industrial Designs Act early history, in 1872, the Patterns and Designs Act was there. Later, 1888, consolidated as Inventions and Designs Act. In 1911, renamed as the Indian Patents and Designs Act. 1970, that is Patents Act was separated from Designs Act. And 2001, Design Act 2000 was implemented. Next. So Industrial Design Act 2000 and the Design Rules 2001, creative activity is there. So visual appearance of a product and 2D or 3D or both made by the industrial process. Next. So the Design Act 2000, that is to protect the design function in industry production, and it promotes the innovation. Design rights are granted on a country by country basis, and first to file system is the on basis actually it is. Next. So when the history of industrial design is there, it started with the 1750, that is Saint Peter at Lyons was founded, and later it was there in 1853 Jacques Eugene Armagod was he was printed in 1853. Then Robert Lepper. Next, the first use of the industrial design was there in the 1919. Joseph Claude Sinel. Christopher Dresser is there. Then Workman, founded in 1907. That is the United States, England and United States it was there. Next, concept of the industrial design, that is applied art whereby the creativity and production. And role of the industrial designer is to create and execute design solutions towards the problems of form, usability, user ergonomics, engineering, marketing, brand development, etc. for the sale actually. Next, concept of industrial design. So you can see here, the concept is for ornamental or aesthetic aspect of a product. You can see the design here. Next, attractive and appealing for the consumers. So when we see the mobile, so you can easily find it. The mobiles has hands-up engine changed now. Next, features of industrial design. So here the features are almost many and varied. That is applied art and improve the product, aesthetics, usability, create and execute design solutions, form, ergonomics, engineering, marketing, brand development, etc., sales, etc. Next. So features again here, the safety, form, color, maintenance, cost, etc., etc. is there. Next. Industrial design, that is deals with the consumer and the human behavior, human machine interface, the environment, product itself. So what is industrial design? So it is concerned with the human aspects of machine made products and their relationship to people and environment. The designer is whole responsible for these products, and the products human factors like engineering, safety, form, color, etc., and cost, it is involved. Next. So classification of design. Next we can. So here the Locarno classification is there. So it is based on the function of the goods, and subclasses are also there. like a sunshades, walking. They have made a classical classification system here. That is, the name itself is Locarno classification. Next, the how to steps for registration, that is finding out whether the design already exists, preparing a representation of the design, identifying the class design, then novelty, including a disclaimer, determining the fee to be paid, and providing full details that is there. So procedure for design. Next. So in the flow chart, you can see that procedure for design of filling, that is filling of application, then examination will be there, then notification, that is the if it is a objection is there, then it is going to be refusal. If it is no objection, then it will go for the registration and publication. Next, pay to file industrial design. So head office is at Calcutta and Kolkata, that is. Now branch offices are Delhi, Mumbai and Chennai. So what can be registered? Here the design which is not new or such a but original in and new in application, not registered in any other country. So such things you can register. Next. So trademarks, we can see the trademarks here. So many trademarks are there, and we can see the trademarks also here. They next. So trademark means it is capable of distinguishing the goods or services of one person from those of the others. Maybe shape of goods or packaging or combination of colors. Trademark, that is having the sign, word, letters, numbers, drawings, pictures, etc. That is applied to the goods or services. It is valid for 10 years and it can be renewable. Next. So trademarks early history, it starts with the 1940, then Trademark Act and Registry, 1958, Merchandise Act, 1999, TRIPS Agreement, and 2013. So that is introduced with the Madrid Protocol. Next one. So meaning of trademark, a trademark, that is a distinctive sign or indicator of some kind which is used by an individual. And a trademark is a device which can take almost any form as long as capable of identifying and distinguishing specific goods or services. Next. Trademarks terms and explanation, that is there. Here the numerals are there, like 555, 000, 501, like that. Symbols, that like we can see that BMW, Benz car, Maruti, etc., etc. Label and ticket, so that will be a label will be there, like paintings or painted on a paper, etc. Name, that is maybe of abbreviation. Color, that is color combination. Then sound, even the sound is also there, like MGM pictures, etc. Smell, even the smell can also be registered. Then containers, which fall within the definition of the trademark. Next. So trademark is typically a name, word, phrase, logo, symbol, design, image, sound, etc., etc., etc. So it may be having the colors, shapes, moving images, holograms, etc. Next. So there is a section 2 ZB Trademark Act, it will be there. That is according to section 2 ZB of the Trademark Act 1999, that is given here. It is a mark capable of being represented graphically and which is capable of distinguishing the goods of services in one form, one person from the others, and may include shape of the goods, their packaging and combination of colors. That is section 2 of ZB Trademark, they have given it. Next. So it offers a legal protection for a word, say a symbol, phrase, logo, design, combination of these. Next. Here we can see that 5 categories of trademarks. So here the fanciful trademarks are there, then arbitrary trademarks are there, then again you will get some generic trademarks will be there. So all these categories of trademarks, we can go one by one, so we'll go fast. Next. So a generic mark here, always the generic mark is having it needs to describe with the qualities, characteristics or ingredients of the good or a business sells. Next. So here the generic mark, we can see that Band-Aid, like that, all Xerox, all these things are the trademarks. Next. So you can see that ice cream shop that is there. So you can see that how the trademark is there on the ice cream shop also. Next. So descriptive mark. So descriptive mark is nothing but statistic or a product service are there. That is the amount and manner of advertising, volume of sales, length and manner of the marks used, or results of the consumer surveys to qualify. And to qualify as a descriptive mark, it should involve brand represents to who the brand is. Next. So here the descriptive mark, you can see that Sony, Intel Inside, Microsoft, Canon, Coca-Cola. So these are the actually descriptive mark. Next. Suggestive mark. So suggestive means that the customer must use the imagination to figure out. Like next, Jaguar. So you can see that Jaguar. So how it is a confusing one. Next. So fanciful mark. Words don't hold any meaning in common language, especially Kodak, Adidas, Nike. Next. So these are the things. Arbitrary mark. Next. So here the arbitrary is nothing but with a well-known meaning, but the meaning in its case is different. Here it is a mark, it is there, but Dove, that is a different one. Next, like a Apple. So you can see that Apple, Dove, all these things are the arbitrary mark. Next, service mark. We can see that service mark that provides services instead of products. So especially services like a service mark examples like FedEx, Walmart, AT&T. So next, McDonald's. So these are the service mark. Next. So trade dress. So dress is there, dress code, that is we can say that a trade dress includes identifying features of a product or a company such as packaging elements, decor elements or other similar concepts are there. So trade dress, it is always having like that. Next. So here the trade dress, you can see that. So in the there is a combination of like Listerine, then all these things are the trade dresses. Next. So trademark classification in India. So see here in India, that is 45 different classes are there. Maybe stationery, leather, household, furniture, textile, games, beverages, hand tools, other scientific and educational products. So group together the similar nature of goods and services. Next. So trademark registration. So how the trademark registration will be there, and it depends upon the Indian trademark law. Types of trademarks can be registered. That is product trademarks or those that are affixed to identify goods, identify the service of an entity, then certified by the proprietor. So it is having the collective trademarks that are registered in the names of the groups. Next. So advantages of trademark registration, that is protects your hard earned goodwill in the business, gives your products a status of branded goods, gives an impression to your customers that the company is selling some standard products, and power to assign the trademark to other for the consideration. Next, procedure or steps for trademark registration, that is filing of an application for registration by a person that is claiming to be proprietor for a trademark, that is in the office trademark registry and that is in the territorial limit. Examination of the application by the registrar, application, publication of the application, then after publication it may be extended to the maximum for 1 month. Then if the opposition has been decided in favor of the applicant, then registration of trademark, the registrar shall be registered through the trademark. Then as per the trademark rules 2002, the application fees is rupees 3,500 per trademark. So next, documents required for filing a trademark application. So trademark logo will be there, then applicant details like name, address and nationality and company, goods or services to register, date of first use of the trademark in India, if it is used by the prior for applying, and power of attorney to be signed by the applicant in 100 rupees stamp paper. On 100 rupees stamp paper it can be done. Next, steps you need to take the registration, that is there. Next, select and authorize a trademark, again an agent or attorney to represent you. Then trademark attorney conducts a search and the trademark attorney will file your trademark application with the trademark office, and it will take 18 months to 2 years for the trademark office to decide whether or not to grant your trademark. Madam, please. Next. Hello. Hello.
Yes, sir.
Next, madam, please.
Ma'am, next slide. Slide.
Highlights of the trademark.
Ma'am,
Highlights of the trademark, please.
There is a problem with the page. Sir, you read out the later slides, please. Because
Yeah.
the laptop is not working.
Okay, no problem. So next is the geographical indication. So in the geographical indication, we can identify how the agriculture or natural or manufactured goods are there, and it is originating or manufactured in the territory of a country or a region or locality in that territory, where given quality, reputation or other characteristics prevents unauthorized use of a registered geographical indication and promotes economic prosperity. So what is geographical indication? That is name or sign used in certain products which corresponds to a specific geographical location or country, like for example basmati rice, Swiss watches, etc. Why geographical indication is to be protected? To denote quality and origin of products, good reputation for the product, preventing the product from generic products, and protecting the domestic market from the competitors. So conditions to get GI, that is geographical indication. It relates to a good, although in the some countries services are also included. These goods or services must originate from a defined area, that is geographical origin of goods. Advantages of geographical indication, that is legal protection and preventing from unauthorized use. Benefits for farmers and local producers, boost the rural development, reduces unfair practices of trade, preserving local culture and resources. How to apply? So, geographical significance of identification, class of goods, geographical area, details of appearance, particles of the producers. So, geographical industry registry is in Chennai. So, you can send through ipiindia.government.in, and validity of geographical indication is 10 years. If a registered geographical indication is not renewed, it is liable to be removed from the registry. So, how the geographical indications are there? Like a Banganpalli mangoes, Tirupati laddu, then Tolpanji rice of West Bengal, Kangra paintings, Kashmira Pashmana, then Nagpur orange, Mysore silk sarees, Basmati rice, Mysore sandal soap, Alfonso mango, Kolhapuri chappal, Nanjangud banana. These are the examples of geographical indications. Next is plant varieties that we can see here. It is for a limited period, and it is to acknowledge the achievements of the breeders of a new plant varieties. And International Union for the Protection of New Varieties of Plants is in the organization, overseeing the protection of new plant varieties. For trees and vines, it is 18 years. Intellectual property rights is there. Duration, and crops 15 years. And data protection is then next new intellectual property, that is set of privacy laws, policies and procedures that aim to minimize intrusion into one's privacy caused by the collection, storage and dissemination of personal data. IT Act 2000 deals with the issues relating to the payment of compensation and also punishment in case of wrong disclosures. So, by the conclusion, we can see that create yourself rather than using others' creations. Do not use competitor's mark in such a way that it harms competitor in unfair way. No comparisons that are likely to cause confusion. Advancement in all sectors is important for our country. Duration of intellectual property in a nutshell. Intellectual property, that is copyrights 60 years, patents 20 years, for different crops and varieties, that is 18 years, trademark 10 years, geographical indications 10 marks. So thank you yourself and for giving an opportunity to speak few words about the intellectual property rights. Some technical problems were there, so for that one is the can't expect. Thank you one and all.
थँक्यू सो मच सर. सरांनी अतिशय सोप्या पद्धतीने IPR बाबतची माहिती आपल्याला सगळ्यांना समजून सांगितलेली आहे. बौद्धिक संपदा हक्क हा अर्थव्यवस्थेचा एक महत्त्वाचा विषय आहे, जो आम्हाला व विद्यार्थ्यांना अतिशय उत्तम रीतीने सरांनी एक्सप्लेन केलेला आहे. थँक्यू सो मच अगेन सर. यानंतर कार्यक्रमाचा शेवटचा भाग म्हणजे आभार प्रदर्शन. आभार प्रदर्शन करण्याची जबाबदारी मी डॉक्टर प्रिन्स आगशे सर यांच्याकडे सोपवते व आपली सर्वांची रजा घेते. थँक्यू सर. थँक्यू सो मच सर. मुलमाणी सर, थँक्यू सो मच सर. Dr. Prince Agashe sir, please vote of thanks.
Thank you, ma'am. A very good afternoon to one and all. On the behalf of MANOHARRAO KAMDI Mahavidyalaya Nagpur, MATRU SEWA SANGH Institute of Social Work, Nagpur, and Ravindrananath Tagore College of Arts, Commerce and Science, Nagpur, I am proposing the vote of thanks. All honorable management members of all three colleges, respected Principal Dr. Usha Sakure ma'am, MANOHARRAO KAMDI Mahavidyalaya Nagpur, respected Principal Dr. Purushottam Borkar sir, Matru Seva Sangh Institute of Social Work, Nagpur, and respected Principal Ravindranath College of Art, Commerce and Science, Nagpur. I am glad to express my vote of thanks. First of all, I would like to thank all the honorable management members, respected principals for their constant support, encouragement to organize such a wonderful programs for all the three institutes. My special thanks to today's resource person, Dr. Vijay Mulimani sir, librarian, Sangameshwar College, Solapur, Punyashlok Ahilyadevi Holkar, Solapur University, Solapur, for accepting our invitation and being here with us today. Sir, your thoughts have truly inspired us and really a wonderful, you have elaborated on all the aspects of intellectual property rights. I also thanks to the all coordinators of three colleges for organizing a wonderful this workshop, and last but not least the participants, their participant friends. I'm special thanks to you for attending this workshop. So thank you one and all. Thank you very much.
Thank you.
थँक्यू सर, थँक्यू सो मच.
Thank you so much, sir.
सर्व विद्यार्थ्यांना एक सूचना देऊ इच्छिते की सर्वांनी फीडबॅक फॉर्म यानंतर भरायचा आहे. फीडबॅक फॉर्मची लिंक पाठवल्या जाईल. थँक्यू सर. थँक्यू मुलमानी सर.
Thank you, Vijay sir.